Good evening. I am your host from PV Legal. What happens when your supplier pockets the GST you paid and never sends it to the government? Today, the Supreme Court answered, ruling that you, the honest buyer, can still lose your credit for someone else's default. This is Bhandari Scrap Traders versus Union of India, decided on the 24th of July 2026 by Justices Sanjay Kumar and Sanjeev Sachdeva. The petitioners, scrap traders, had paid GST to their suppliers in full and claimed credit, only to have it reversed when those suppliers failed to deposit the tax. Here's the law at issue. Section 16 of the CGST Act lets a buyer claim input tax credit, but only if certain conditions are met. One condition, Clause C, says the credit is available only if the supplier has actually paid that tax to the government. The petitioners called this unfair. They had no way to verify their supplier's return, no access to the supplier's filings, and no control over whether the supplier paid at all. The law, they said, was punishing them for a stranger's dishonesty. And they asked the courts to strike it down. 3 questions were before the court. Was Section 16(2)(c) unconstitutional for punishing an innocent buyer? Could the protection Delhi courts gave VAT-era buyers in the Arise India case apply equally to GST? And did the law's built-in safeguard, letting a buyer reclaim credit once the supplier eventually pays, make the provision fair enough to survive? The petitioners leaned heavily on Arise India and on a recent Tripura High Court ruling that had sided with buyers months earlier. The Supreme Court disagreed. It held GST is structurally different from the old VAT regime because under GST, once the government recovers tax from a defaulting supplier, the buyer can reclaim the credit it lost. That safeguard didn't exist under VAT, which is why Delhi's courts intervened there and why this court wouldn't intervene here. In the court's own words, there was, quote, no possibility of drawing parity between the two laws. The petitions were dismissed and Section 16(2)(c) stands as constitutional. But here's the twist. The Gujarat High Court itself told the government it's high time to fix this problem for honest taxpayers, even while upholding the law as written. Our takeaway: don't rely on a supplier's invoice alone. Reconcile against GSTR2B, vet your suppliers, and add indemnity clauses to your contracts. And watch this space. A similar case from Tripura is still pending and could shift this picture again. For the full legal analysis, read PV Legal's daily newsletter. I'm your host from PV Legal. Stay legally informed. Stay alert. Good night.